God save the United States of America, the state of Tennessee, and this honorable court.
Good morning and welcome to the morning session of the Tennessee Court of Appeals. I want to take just a moment before we get started and introduce our panel for this morning. Our panel will consist of Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah. I'm Steve Stafford from Dyersburg. Obviously, we have experienced practitioners here, so you know how this works, but just in an abundance of caution, each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, please request that from the court after you introduce yourself and before you begin your argument. Appellee obviously does not get any rebuttal time. I want to thank Mr. Hibner and his staff for what they've done to make this process work. Also want to thank the technology men and women of the AOC staff. They have done just yeoman's work in making this process work. And we certainly want to appreciate the attorneys, or tell you how much we appreciate the attorneys and the parties for participating in this. This is not the optimum situation, but it's the best we can do under the circumstances that currently exist, and we appreciate you participating. Having said that, Mr. Hibner, if you would call the first case, please.
Rodney Stafford et al. Versus Christy M. Lucas, APN et al.
All right, we will hear from the appellant.
All right. Good morning, Your Honor.
Good morning.
I am Louis Chioza here in Memphis, talking to you from my conference room. With me today is Christopher Lewis, he's an attorney, and also Jennifer Mitchell, she's an attorney. She's with me today just to hear the arguments. I would like to reserve, if I may, 2 minutes for rebuttal.
All right, sir, you may proceed.
Thank you, Your Honor. We're here today, Your Honor, to determine if the lower court in this particular case was correct or incorrect in dismissing my Health Care Liability Act case, stating that the statute of limitations was not told in this case. It's important for us, I think, in dealing with this case to sort of give you a rundown chronologically of what occurred. The plaintiff in this case did send a timely 60-day letter out, filed a complaint in February 24th, 2017, and with that complaint issued summonses. The summons was returned not to be found, and on July 21, 2017. On September the 5th, 2017, aliases summons were issued, and they were served on the defendants on December the 6th of 2017. That was 2 days after the 90-day period for serving or getting service on the defendant. After we got service, we received a call from a defense attorney asking for an extension to file an answer, which we agreed to. They filed a notice of appearance on January 22, 2018, and they filed an answer on December 7, 2018. In the answer, they did state that they would rely on some defects in the service as far as the 90 days was concerned in this case. The defendants filed interrogatories to the plaintiff, and we responded to the interrogatories as well as the other motion for production. In addition, the defendants were requesting the deposition of our client, and we were trying to schedule that when they filed the motion to dismiss on November 2nd, 2018. A hearing was held in circuit court on April 5th, 2019, and the court felt that the statute was not preserved in this case. Now, we argued to the court that Rule 3 of the Tennessee Rules of Civil Procedure simply require a plaintiff to issue, if you get a not to be found return, well, excuse me, let me start over. If you file a complaint as we did, and you get a not to be found return, in order to rely on the original filing, as the court well knows, you have to reissue summons within the year. We did that in this case. We reissued our summons. It doesn't say anything about reissuing plurries or anything of that nature. It just says reissue your summons within the time allowed by the statute, and we did that. So as far as the statute of limitations is concerned, it's our contention that we complied with the statute of limitations in terms of reissuing our summons. Now, the defendant in this case was served with it, but he was served 2 days after the 90 days. But they did participate in the lawsuit. They did file responses, and they did everything that they were supposed to do in terms of keeping the lawsuit going. So we felt that we had preserved the statute by filing timely our alias summonses and getting them served. The court disagreed with us, and we're here today to argue. Now, the most important part of our argument, I feel, is that Rule 3 says that if you get a not to be found return or it's not served for any reason, that the plaintiff cannot rely on the original commencement of the tolling of the statute of limitations. Then it goes on to say, unless the plaintiff continues the action by obtaining issuance of new process within 1 year from the issuance of the previous process. If no process is issued within 1 year from the filing of the complaint. Well, we issued process and it was served. So as far as the statute of limitations is concerned, it's our contention that we had complied with that, and the court should not dismiss our case. Now, there's a number of cases that we've cited that I'd like to point out to the court that have dealt with this, not this exact issue, but something similar to it. I noticed that we cited the case of Fair, and that case involved a issuance of a summons that was served on the defendant, but it wasn't filed with the court for 400. But they said that was because the statute said that Rule 3 rather said that just so you reissued it, it doesn't make any difference when it was filed with the court if it was served, and that took 412 days. Another case that we cited was the Fault case, where the defendants in that case waited 2 years to file a motion to dismiss on a technicality, and the court felt that that was inappropriate to wait 2 years and participate in the lawsuit and then tell the plaintiff that you're going to try to take advantage of a technicality. So we've cited a number of other cases that deal with Rule 3, and especially the Harris case, which says that discusses the interplay between Rule 3 and Rule 4. It specifically says Rule 4, meaning when you serve a paper and what time frame it has to be served in, does not mention the statute of limitations. For finding of a statute of limitations, Rule 3 talks about to satisfy the statute of limitations, you have to refile your complaint, which we did in this case, but Rule 4 mentions nothing about it, and it's our contention the defendants want to try to intertwine the two and say that they have to work in conjunction of each other, but we feel differently because these cases we've cited have stated specifically that you do not. You rely on Rule 3 when you're talking about the statute of limitations, and we relied on that in this case. The Hines case says the same thing, And, but if the court does not agree with us in this particular instance, we have also argued that we feel the defendants in this case have waived their objection because this is not a case where we didn't get service on the defendant. This is not a case where we didn't issue our 60-day letters. We did all that. He just got served 2 days too late, evidently so. But we feel that they have waived their argument in this particular case dealing with process because they have filed a notice of appearance, they have filed an answer, they have asked for an extension, which we gave them. They actively participated in the defense of the case. They filed interrogatories, and then they were in the process of scheduling our plaintiff's deposition, and they simply said, we're going to file a motion to dismiss, which they did.
What did the trial court rule on your waiver issue?
They did, actually, she just made one blanket statement regarding the waiver issue, and she just said that all the other issues that we argued were denied.
And what other issues were those?
The other issues, Your Honor, were the primary one was the Rule 3, that you didn't have, that the Rule 3 argument that we had that we're making to you today was primarily it. And the other arguments were that they were stopped to allege that we had not complied with the statute. And the biggest one was we requested under Rule 602 that the court enlarge the time in this particular case, since it only involved 2 days, since it would represent no prejudice to the defendant, because he got a 60-day letter, he'd been served with the lawsuit, that she could, under 602, exercise her discretion and extend the time to issue that summons, and or just say, I'm not going to dismiss the case because everybody has acted in good faith and nobody's going to suffer any prejudice for it. But she didn't go into any detail on why she didn't do that or anything of that nature.
Well, I mean, did the trial court obviously denied the motion to enlarge, but did the trial court say why it was denying that or any of these other defenses?
No, Your Honor.
Okay, thank you.
Yes, sir. And if I just might make one more argument, I've got 2 minutes left, I believe.
Yes, sir. You go ahead.
So we're alleging that the defendant should be stopped from alleging it at this point in time, and that it would be, as far as Rule 6 and 602 is concerned, Your Honor, we were going to allege or present to the court that we meet all of the factors that are set out in that particular rule. In other words, there's not going to be any particular prejudice to the defendant because they got a notice letter, they received a notice letter, they received the lawsuit, they answered it, and they filed everything they needed to file for us to answer in the way of interrogatories and production, and the lawsuit was moving very rapidly or very timely when they decided to exercise what they perceived to be their right under the statute and stated.
Let me ask you a question, Mr. Giozzo.
Yeah.
Obviously, you had requested a enlargement of time.
Yes.
Did the trial court conduct a hearing on that motion?
No. Oh, well, it was included in my argument to the court.
I'm not sure I understand what you just said.
When I argued the motion to the court, we included all the arguments that we've included in our brief today.
Okay, so this was an inclusive argument where you presented your motion to enlarge as a alternative argument, I'm assuming.
Yes, sir, that is correct.
Okay. All right. And did, other than the trial court just saying the statute ran and I'm denying everything else, is that basically all the trial court said?
Yes, sir.
Okay. All right, sir. Thank you. You've used your initial time and you have your rebuttal time left.
Yes, thank you.
All right. We will hear from the appellee.
Good morning, Your Honors. Judge Stafford, you and I have known each other for a long time, but Judge Golden and Judge McGee, I think this may be my first occasion to see you and appear before you. And good morning, and it's my pleasure to be here.
Glad to have you.
Tim Weiner. I am of the Jackson-Madison County Bar. Occasionally, they let me venture to Shelby County, and that's what brought Mr. Chioza and I together on this case. And I represent the remaining defendants in this case, Christy Lucas, a nurse practitioner, and her clinic. The other defendants have been non-suited. Your Honors, I think it's important to—
I think you need to identify yourself, sir. I think you need to identify yourself. Maybe I missed.
Tim Weiner of the Jackson-Madison County Bar Association, here for the remaining defendants.
All right, sir. Thank you.
Rule 4 of our civil procedure rules states if a summons is not served within 90 days of issuance, it shall be returned, and the reasons for its failure to be served stated. The plaintiff may obtain new summonses from time to time, as provided in Rule 3, if any prior summons is returned unserved, or if a prior summons has not been served within 90 days. The advisory comment to Rule 4 explicitly says that it has a definite time frame of 90 days in which summons must be served or returned. Here, it is undisputed that the summons, the alias summons that was issued in a timely manner on September the 5th of 2017 was not served within 90 days. It was therefore, it should have been returned, but it was served after that. We properly pled that in the answer, and that then started the 1-year clock for the plaintiffs to have service or have a summons reissued under Rule 3. And we did conduct some initial discovery. Our Supreme Court has made clear that once it's properly pled, that is not a waiver for a party to participate in the litigation. And we waited until it was a ripe issue for the court, which was after the 1 year passed, September the 5th of 2018. In fact, we waited until November to file this motion. Let
me ask you a couple of questions, Mr. Weiner. First of all, we're talking about 2 days. Is that right?
Yes, Your Honor. 2 days, exactly.
Okay. So Mr. Chioza has said that he filed a motion for enlargement of time and that it was denied for whatever reason, who knows. Is that accurate?
That is accurate. 16 months after the fact, after the statute had run, on the day of the hearing, initial setting for the hearing, the motion for enlargement of time was filed, and it was presented to the court by Mr. Chioza on May the 1st in that hearing. And the judge, Judge Smith, drafted her own order. And on page 252 and 253 of this appellate record, she states, after summarizing Rule 3 and 4 in pertinent part, she said, service was not made or returned within 90 days. This court is unaware of an exception to this rule or authority to expand the time for service. This defense was raised in the answer filed by the defendants, yet no subsequent alias was issued in order to achieve proper service. And then on the last page of her order, she said, it's therefore ordered, adjudged, and decreed, defendant's motion to dismiss is granted. This is a final order, and any matters not specifically ruled upon are hereby denied. So the court did not make special findings of fact or rulings of law like it would for a judgment in denying the motion to enlarge time. But clearly she did have that in mind because that was the only other motion pending before the court other than the motion to dismiss. And respectfully, I think that that satisfies the record in the trial court's ruling. And I don't think she has to have specific findings to justify that denial.
Now, let me ask you a question. The court
Yes,
said
sir.
in its order that you just read, this court is unaware of any exception to this rule or authority to expand the time for service. Isn't that exactly what Rule 6 is?
Your Honor, respectfully, our court has said that the rules, particularly the rules 3 and 4, are to be strictly construed. This court said that in Watson versus Garza, and it cited the Supreme Court in Hall versus Haynes, both of which are cited in our brief.
Are you telling me that Rule 6 can't be used to expand the time or enlarge the time in a circumstance like this?
I think if it was timely applied and excusable neglect was shown,
How do we? Let me go there with you, because that's kind of where I'm wanting to go.
Okay.
Mr. Chiozzo said that in his motion that excusable neglect had occurred. He asserts certain things, which I assume were brought out in the hearing. They're contained in the motion. Here we have a blanket denial and a statement that I'm not sure is accurate, that the court is unaware of any exception to this rule or authority to expand the time for service. So how do we know what the court thought or what the court did? All we've got is a denial. And with all due respect, when you get a motion to enlarge time, there are a plethora of cases that go through a very thorough analysis of how a court is to consider that motion, whether it be before the expiration of time or after the expiration of time, as Rule 6.01 and 02 contemplate. That's a lot of words. So what I'm trying to figure out is what the court do here, why did the court do it, and how are we supposed to review it?
Well, Your Honor, this was briefed when the plaintiffs on the first motion hearing filed the motion for an enlargement of time 16 months after the fact.
That's a factor. But what does that mean? That's a factor.
Well, it was briefed and it was argued, and the court simply found there was no basis warranting an enlargement of time, and she's clearly denied that motion.
She denied the motion, but why did she deny the motion? What was her analysis? What was her thinking?
Well, she found that there was no basis for an exception to the time frame set forth in Rules 3 and 4. That is...
I don't think we even get there. I think we're looking at the question of enlargement of time before we get there.
Okay. Well,
so I mean,
it sounds like the court is headed for a remand to get some.
I'm not heading anywhere. I'm just trying to figure out what's going on here.
Well, I can tell you, Your Honor, that the issue was argued, it was briefed, it was presented to the trial court who drafted her own order. And Rule 6 says if a motion is made after the expiration of the specified time, which clearly this was, then there has to be excusable neglect shown. And excusable neglect, our Supreme Court, and this was argued to the court, the Supreme Court in the Williams case, which we cite on page 32 of our brief, A failure to meet a deadline may have causes ranging from those beyond their control to those within it. Those beyond their control will substantiate a claim for excusable neglect. Those within control will not. I think the court implicitly ruled in her denial that, without specifying it, that there was no basis for excusable neglect with a 16-month post-event motion for an extension of time, respectfully. And the court was presented with this. She drafted her own order and it was briefed. So I think it is addressed and it's covered enough for this court to rule on the merits. Additionally, Your Honor, there is no waiver. Our Supreme Court has.
Well, let's go to there.
Okay.
Because he said, if my notes are correct, it says that Mr. Chiozzo asserted waiver, estoppel, and excusable neglect. Would that be accurate?
Yes.
And
Yes,
again,
sir, that is
all
accurate.
we've got is a blanket denial of everything's denied.
That's correct. She did
Okay.
not go into specific details, but she did address it in those 2 paragraphs of her order.
Well, respectfully, you're going to have to help me there. How
Yes,
did
Your
she
Honor.
address that?
I think she addressed it on page 252 of the appellate record at the last paragraph of her order. She
Well,
said,
But hold on just a second, though. She says the court's unaware of any exception to this rule or authority to expand the time for service. Obviously, that's what Rule 6, if Rule 6 means what it says, it's an exception. It allows you to expand time, so that's not an accurate statement, I would assume. And it is an exception. So is that what you're relying on also, or just the blanket denial on the next page? Everything not specifically ruled upon is denied as far as waiver and estoppel and excusable neglect?
exactly right, Your Honor. On page 253 of the record where she makes that, bear in mind that the only other motion pending at the time of the motion to dismiss was the motion to enlarge time to achieve proper service. That is the only other matter that was pending, and that is clearly what the judge had in mind when she issued that statement in the last paragraph of her order on page 253. But if we need clarification, we can get that. Your Honor, one other point I might add, this argument of the plaintiff that because they had an alias summons issued in a timely manner, somehow relieves them of any other obligation to get another summons issued timely. I wanted to point the court out that this court in Crump versus Bell, a 2002 opinion, dealt with a third summons, a pluris summons as it is known. And in that case, the first 2 summons were issued timely and were returned not served. And then a third pluris summons was issued, but it was issued more than 1 year from the date of last issuance of the alias summons. A motion to dismiss was filed. The trial court granted it. This court affirmed the dismissal, and in so doing said that the pluris summons was not timely issued. So I think the position that Rule 3 is satisfied if you get 1 summons reissued in a timely manner, and that protects you in perpetuity, I think that is inaccurate, and a review of the cases, including the Crump v. Bell case, would confirm that, Your Honor. Your Honor, in the 40 seconds that I have remaining, I would like to state to the court that we believe that in looking at Rules 3 and in Rule 4, they were not satisfied This summons, when it was served, was stale. The statute of limitations has long since run, and more importantly, Your Honor, the statute of repose had already run at the time of the motion to enlarge time. And I would submit to this court that there was no cause of action to be resurrected since the statute of repose had extinguished it. That's an issue that's important. It's not been addressed, but I think it's valid, and this court should affirm the trial court's dismissal. Thank you, Your Honors.
Thank you. We'll hear rebuttal from the appellate, please.
Thank you, Your Honor. As to Rule 602, I would like to briefly review the factors that I had pointed out earlier. I don't think that this would have represented any prejudice to the opposing party or the defendant, because he received a 60-day letter. He filed an answer, even asked for an extension to file the answer. They filed a notice of appearance in the case. They filed interrogatories. They filed everything there was to file in order to keep this lawsuit going. So I don't think that there's any prejudice to them as far as not knowing about the lawsuit, not being served with the lawsuit or anything of that nature. Second factor would be the impact on the proceedings. This case was rolling right along, and I don't see how there was any adverse impact on the proceedings by allowing us to issue another summons, or to just simply state in the record that the summons would be classified as acceptable or good. The third factor would be, would it cause any undue delay? And we certainly didn't see anywhere in this case where that would have caused any undue delay, because there was none. If the court had allowed us to go ahead and issue the summons as we requested. And last, this wasn't done in good faith or bad faith. I guess if anything occurred, I got, as lawyers do from time to time, busy, and but didn't notice this issue. But let me just make one quick statement. Tennessee Supreme Court in Williams said, excusable neglect encompasses situations where parties' failure to meet deadlines was caused by forces beyond its control, forces within the party's control, a simple faultless omission to act, and more commonly, omissions caused by carelessness. Thank you very much for hearing us today.
Thank you, counsel. We certainly appreciate your argument. We will take this under advisement, and we'll try to render an opinion at the earliest possible date. We again appreciate Mr. Hibner and his scheduling of all this and making it happen, and his staff, as well as the AOC technology staff. Mr. Hibner will stand in recess until the call of the next case, please.
This honorable court is now in recess until 10 a.m.
Thank you.